Good evening to all those on the dais and off the dais. I had been a lawyer for about half a century now. But I think I was a lawyer, mediator, and arbitrator put together. I never brought a case before a court of law, either civil or even private complaint, criminal, unless I have made an attempt to mediate if possible. Of course, in certain situations, after failing in the mediation, I had to give up the engagement of the client who initially wanted to engage me, because after several rounds of discussion with both parties across my table, whenever I have felt that I will not be able to avoid a suspicion from one of them, both of them are divorced and sent to different lawyers. It is possible. Now we are speaking about arbitration, mediation, conciliation, etc. with an objective. That is, we want to de-burden the courts of law. We want to speed up justice to the poor. Both these can be achieved if suitable legislative provisions are made in various enactments. Even now, we know, if in a family court, as soon as a petition is filed, there is some counseling, some attempt to reconciliate. We have got Section 89 of CPC. So many changes are made in the law, but the crux of the issue is not taken care of. For example, I was presiding over an Adalat recently, National Adalat, last Saturday, second Saturday, it comes. 60 cases were listed before a bench where I was one of the partners. Sitting High Court judge was there. We sat there between 10:30 and 1. We could dispose of, finally, by recording settlement, 3 cases. Only in 3 cases where parties were present. Only in 3 cases parties. Of 57 cases, neither lawyer nor the party is present. There itself I suggested that case is coming before the Adalat after several rounds of posting in the court hall. 2008 appeals, 2008, 2009 appeals have come after spending a decade in the courtroom. I suggested, as soon as an appeal is filed before the High Court and numbered, before sending it to the judge and wasting the time of the judicial time, why don't you place it before a mediator or an Adalat? Even a single man will be sufficient. Sometimes at the first stage, within 1 minute, matters could be settled. I had experience in the same court hall where when parties were present, matters are easily settled because parties do not want to drag the issue. There are only certain vested interests in the legal profession may like protraction. So protraction will be avoided by parties. Therefore, in the arbitration law, it should be made democratic by permitting appointment of arbitrator by parties. Of course, by mutual consent it is possible now. But rarely 2 parties will agree on 1 man. There is credibility crisis, as it was tried to. Nobody believes anybody. And we should create a culture where at least 100 people will be available in the whole of the nation. Lawyer, chartered accountant, or company secretary, or professor, principals, whoever that be. Trustworthy persons must be there. For that, what is needed is education. Education, we said in the morning also, we were saying we want to have a change of attitude, change of mindset, etc. This cannot be taught in a classroom. It is taught by behavior in the society. So in the society, all men from all walks of life should attempt to create a situation that is at least some person has to be trusted. And therefore, we will trust a judge of the superior court, of the higher court. That is how it says. Somebody has to be trusted. That is why everybody immediately rushes to the court with a mandamus petition, because there they expect something, either court of law or equity, something will be speedily done. But overburdening 4,000 cases in 1974 when I, 71, now it is 40,000 or 50,000 writ petitions in Kerala High Court itself. So multiplicity of proceedings, and every time there is no finality about anything, and if it is really an arbitration by a person who is agreed upon by both parties, there is no scope for any further litigation in the courtroom. Even now the arbitration is not the end of the music. It is only the beginning. Again, section 34, section 37, everything is there. So that unending process in which justice becomes a distant dream, that should not happen. Therefore, as the other day, my friend Venugopal C. Govind was speaking about values. Truth and fairness is the values to be inculcated. That has to be inculcated among lawyers, among judicial officers, among law professors, among chartered accountants, among company secretaries, among directors of the company, and various people of various walks of life. If you tell the truth, there is no difficulty. For that, in pursuit of justice was Justice Malimath Committee report, there must be drastic change in the law. Change will be resisted. Definitely it will be resisted. And every time, whenever a change is attempted, it is resisted. Who resists it? Who is resisting a change? Only 2 or 3 groups will change resistance. One group is those who are ignorant. They don't know what will be the result of that. They are ignorant. So that every time when a change is proposed, they resist. Second group is those who are afraid. This change will give me some trouble. I will be in soup, therefore I resist. The third group is, I am very greedy. I am a status quoist. If change comes, my present situation, my present earnings will be affected. All these has to be dispelled by proper education. Perhaps that is the purpose of institutionalizing this arbitration system. Law, of course, in the statute book will be several 1940, 1996, further amendments, so many 110 constitutional amendments. We have change of law. We have improvement in the judicial strength. We have multiplicity in the lawyer's strength. But where is the result? Are we able to resolve some dispute? Or have we not increased the number of disputes in the free India? Kindly consider. And then make suggestions to the government to legislate strictly. One suggestion I would make is there is a permanent law Adalat system under the Legal Services Authorities Act 1987 in a limited area. That is for the public utility services. And one district judge retired will be presiding over that. There, when the matter is taken up, an attempt is made to conciliate. If no conciliation, award is put. Here, other adalats, lot of time is wasted for conciliating, and if no conciliation, again it goes back to the judicial forum, again for consuming time. I think will be possible under law, under Legal Services Authorities Act, to provide for attempt to conciliation, and then failing which, award, finish up that. Of course, a single lawyer, if he wants, matters can be conciliated outside. Rent control matter, matrimonial disputes, maintenance cases, even disciplinary cases of government servants. I have negotiated and settled. Sometimes I have told the inquiry officer of the P&D department, why are you protracting this matter? Sir, what I should do? You impose a major penalty. What? Yes, sir. You impose a compulsory retirement. Like that, matters are closed. When things are studied and practical view is taken in every sphere of litigation process. Conciliation can be attempted, mediation can be attempted, and if parties are agreeable, arbitration, which will be the last word, will also be possible. For that, we should have some legislative provisions. Let us recommend that. Thank you.